All right, looks like we are live. I'm George, one of the co-founders of SoloSuit. Looks like audio and visual are working all right. If not, go ahead and let me know in the chat. Let me just make sure things are good to go. All right, audio and visual should be working just great right now. All right, glad everybody's here today. We got lots of people on the webinar this evening. Glad you're all here. So I'm going to be going over some of the basics on how to respond to your debt collection lawsuit. Our wonderful assistant Hannah is going to be responding to some of your questions in the chat. I'll also be responding to them verbally on here. I'm going to go over to some of the basics here to begin, and then we reserve most of the time for your questions. We will end half past the hour. All right, we got lots of people on, so go ahead and make sure you get your questions in on the chat. Alrighty. So this is our website, solosuit.com. If you haven't been, you can just type that in, solosuit.com, check it out. Most people come to us once they've been sued for a debt lawsuit. You can come on here and click reply to a debt lawsuit. That's probably the first thing you're going to want to do if you've been served. You'll see we have a 4.7 star rating on here. Reviews mean a lot to us. If you've had a good experience with SoloSuit, go ahead and leave us a Google review. That would mean a lot. I can check out some of the good reviews here. We got one from Abu Bakar. They're trustworthy, not too pushy. There's no catch. I'd go back to them if I ever have a situation like such in the future. I highly recommend them. Thank you, Abu Bakar. We got a review from Derek. Process to start was simple, hoping the rest of the process is just as flawless. I hope so as well. Jasmine, they were knowledgeable and prompt, very helpful team. Thank you. Kathy, awesome tool. Easy to navigate. Thanks. Great. All right, so we're making people happy. Always glad about that. All right, so go ahead. You'll go on. For purposes of the demo here, I'm actually going to log out of my normal account. And I'm going to come in. So click the reply button, then you'll get started. And you will make a new account here. Ready. And you'll make an account. You can confirm your email address with us. That's always helpful. And you'll come in. It'll tell us what state the lawsuit is in. Let's choose Hawaii for today. And you'll come on in here and you'll be able to choose your package. The standard package, you create the answer document on our site, and then you can pay us and use our software to file for you automatically in your court. All right. Or a lot of people do the premium package. It's also very popular. We will also have an attorney review the document for you. It's a third-party contracted attorney that will review the document. Depending on your state, the attorney can also provide a 15-minute phone consultation, which is real helpful if you have any questions regarding your case. All right, so now it does take between 1 to 8 days for us to file on the standard. We can get it done in 1 day if you provide us all the information, you're real responsive, make sure you upload your complaint and summons on the website. And we can do that if we are e-filing. If your court supports and has a good e-filing system, we might e-file the document for you there. Otherwise, the document is sent by USPS certified mail with tracking numbers. It can take 3 to 5 days to arrive at the court. If you do the premium option, again, we want to make sure you're super responsive. We might e-file the document for you, or we will send it by 2 to 3 day priority mail for your court. The reason we file by mail is that it is the only standard way to file court documents across the country. So usually we will file the document by mail for you. All right, so that is the basics on this. You'll just answer a few questions. You want to make sure you have your complaint and summons with you, or your petition and citation, depending on what state you're in. And then you'll basically enter in some information from those. You want to enter your full name here, tell us who's suing you, etc., etc. All right, so pretty straightforward there. Once you are done with that process, you'll come out here on your dashboard. Then you can click the Learn More button if you want to settle your lawsuit, which most people do want to settle. Come on over here to our Solo Settle product. You'll do some of the same stuff here. You'll tell us a little bit about the case, tell us your name, and then you'll tell us how much the lawsuit's for and what you want to settle for. Then we'll take that offer. It's free to make an offer. We'll send it to the collector for you, and then we'll put you two in a structured negotiation on our debt settlement marketplace. And then once both parties agree on a settlement, then you will be able to transfer the settlement amount to the collector and get that all wrapped up nice and tidy like and get a good outcome. All right, right now, most of the time, debts settle for about 71% of the face value of the debt. We don't guarantee outcomes, and they don't always get the settlement that you're necessarily looking for, but we are regularly getting good settlements for people all the time. We had one debt settle recently where the person was able to knock off about $11,000 in debt. So they ended up saving $11,000 when it was all said and done. Just deleted it just like that and got that thing settled. All right. So that's the overview. I'm going to jump into whatever questions you have now. All right. I'm going to try to be pretty quick as we go through. All right. First question from Car Scientist. Business judgment just signed in Florida. My company is in Texas. What are my options? Okay, so it sounds like a judgment was signed maybe, or the judge issued a judgment. If there's a judgment against you for a debt lawsuit, that means that you lost the debt lawsuit. So you have somewhat limited options. If you never responded to the lawsuit by filing an answer document, a capital A answer document in the court, then you could potentially file a motion to set aside judgment in that court, and alongside with an answer document saying, hey, I never responded, I shouldn't lose on supplementality, my answer document should be considered. You can try that out. We do see pretty good results with it. You can email us at our support at solosuit.com email address, and we can send you a template that you can fill out and include it with your answer document. So that is a pretty good option. You can also try settling if they have a judgment. They're probably going to try moving towards garnishment. You can try settling even then. They do pretty regularly settle. Probably going to have to pay a significant amount of money up front to get a good settlement, or potentially settle like balance in full. It might be a win still, considering that once there's judgment against you, there's usually 10% around there, 10% post-judgment interest applied to your debt. So it is going to increase in size over time. So if you can pay it now, that'll be the best. All right, HEMA. I was met with a car accident without car insurance. Our state transportation department suspended my driver's license and my husband's registration privileges. Could he be able to buy and register another car in his name? All right, that's an interesting question. Doesn't sound like you're being sued for debt. This webinar is particularly for people who are being sued for debt and they're interested in using SoloSuit to help them resolve that. That said, happy to try to help where I can here. This is probably a good time in the webinar for our disclaimer. I just want to make it clear I'm not an attorney. I'm not your attorney, so this is not a law firm or not your law firm. We don't provide legal advice. This is just a webinar. Shouldn't be construed as quote-unquote legal advice. There's no attorney-client privilege or relationship made on this webinar. Those are some things I say because of regulations in the space, all right? So, HEMA, you're wondering if your husband will be able to buy and register another car. I mean, it sounds like his privileges have been suspended. His registration privileges have been suspended, so he probably sounds like he can't register another car. I'm not super sure. I'm not sure why your husband's. I really don't know much about that topic, honestly. So I'm not super sure. Best of luck. Hope you can find some help out there, and hopefully get some car insurance for next time. All right? Hopefully you get your license back. All right, Brock. Called debt company for a payment plan, and they sent me an agreed judgment to sign and scheduled a new court date for April 18th. Should I sign this? I was under the assumption that this would be handled outside of court. They also gave me 14 days to sign and to return. Is there any reason to sign and send before the court date? Have an arrangement making first payment next week. Thank you, guys. All right. So it sounds like you settled the debt directly with the collector. So nice work. Or at least you have a settlement offer. So the agreed judgment is normal. Yes, for most collectors, they're going to require in a settlement a stipulated judgment. So what that means is the settlement agreement that you sign will usually indicate that if you don't pay the agreed upon settlement amount, you agree to have a judgment entered against you by the court, and the collector will be able to then proceed with garnishment, and you will owe the full amount of the lawsuit. All right, so if you get a settlement on a $10,000 debt for $5,000, and then you sign this stipulated judgment, and then you don't pay it, then the collector will get a judgment against you, and then you will owe the whole $10,000 again. All right, so that's pretty normal. It's pretty common. Collectors really aren't trying to be like jerks or anything about this, right? It's just something that they do to cover their butts in this situation. So it's pretty normal. You want to read the judgment. We can't tell you exactly whether you should sign it or not. Generally speaking, it's safe for somebody to sign. I would probably sign if I was in this situation. And then you just want to make sure that you make all of the payments. Don't miss any of the payments, because usually if you do miss a payment, they can get that judgment against you. All right, so just make sure you don't miss any of the payments. And then as far as signing it before the court date, yeah, probably they're looking to have it settled so that nobody needs to show up at court. That's one of the big reasons to settle, because showing up at court is difficult, time consuming, so they want to settle that before. That's why you would want to settle before the court date. If you show up at court, they might not want to settle anymore if you go all the way to the court date. All right. Beast. We got a question from our man Beast. I'm gonna pull up my little whiteboard connection here as well. Just give me 1 second to do that. Okay, I don't know if that is going to work. All right, let's looks like we're not going to try out the whiteboard today. That's not working. So moving on. All right, Beast. If you dispute a time-barred debt with TransUnion, does it restart the statute of limitation time? If you dispute a debt, I'm not sure exactly how you dispute it. Maybe send them a debt validation letter or something like that. No, that's not going to generally restart a statute of limitations. Statute of limitation clock usually gets restarted if you make a payment on the debt. That is usually what will restart that debt. Okay. Okay, just I'm back. All right, Eric. I obtained the judgment in my case back in September 2013, which is now being pursued for renewal since it expired in September 2023. So when you say I obtained the judgment, let's see, go on. His debt stemmed from a family member needing funds for their business. I've raised affirmative defenses using solo suit, arguing that the debt falls under the statute of limitations, denying ownership of the debt and pointing out the plaintiff's lack of pursuit. As the case from North Carolina awaits a court date, I'm considering whether it's advisable to settle with the collection agency before the hearing. I'm concerned about the potential negative impact on my credit and financial risks associated with losing the case in court. Your thoughts on the best course of action would be greatly appreciated. Well said, Eric. It's one of the better worded questions we've had on here, so I appreciate the context there. It sounds like you're saying you obtained the judgment. It sounds like there was a judgment against you in a case in 2013, and now the collector is trying to renew the judgment. Yeah, judgments oftentimes last for like 10 years. That's pretty normal. They have their own statute of limitations. It's usually about 10 years. Renewal is quite easy. Usually the collector just needs to file a renewal and then it gets approved without really any questions asked. That's one of the big incentives to avoid getting a judgment against you in the first place. But it sounds like you already have the judgment. And yeah, it might be on your credit. You might want to do a credit check. After 10 years, the judgment might actually be off your credit report. And maybe settling it might bring it back on, might bring a new mark on your credit report. Not super sure there. Generally speaking, yeah, settling is going to be the best course of action. Even if you win a lawsuit or if they don't collect on it, it's still going to be out there. They can collect on it. But if you settle something, it really wraps things up. They won't sue you for it anymore. They won't try to collect on it outside of court. You can just get it fully wrapped up. So settlement's a good option if you have some amount to pay them for a settlement. That'll be a big win, and hopefully you can just get that wrapped up. If it's off of your credit report though right now, you might want to consider your options. Yeah, right. You might want to consider maybe you don't want to settle if it's off your credit report, but you should know that they are very likely to successfully renew that judgment. All right, Ulysses. Hello. Hello, Ulysses. Glenn, hi. How long before trial date should one submit request for arbitration? Generally speaking, you can submit a request for arbitration pretty much technically like anytime, but generally what's considered like best practice is just to submit it as early as you can. Not much of a reason to wait. All right, method. I received an email from Calvary, looks like you spelled Calvary, debt collection, letting me know that they are servicing the debt from my credit card I had at Costco. Do I need to wait until they file a lawsuit? So fun fact, you got Calvary, where I believe Christ was crucified, right? That's like Calvary. And then you got cavalry, which is actually like, we usually use the word for cavalry, which is the like the group of horses, people that come in the battle, guys on horses. That's cavalry, and this debt collector is actually cavalry. So it's spelled Cavalry. All right, just a fun little fact there. Things you find out when you spend a lot of time in this space. All right, so you're asking. So cavalry is letting me know that they're servicing the debt. Do I need to wait until they file a lawsuit to reply? No, you don't need to wait. So they sent you a letter, like just basically they sent you a collection letter. Sounds like. If you want to take that letter and then if you want to pay off the full debt, you can try doing that. It means Cavalry probably owns the debt. They probably bought the debt from like Synchrony Bank or whoever backs the Costco credit card. So you can't pay the Costco or the bank anymore for that debt. So you have to work directly with Cavalry. You can contact them and try to pay off the full debt, or you can try to get a settlement right now. They'll probably be pretty happy to hear from you, and you can try to get that settlement done. Debts actually settle for a lower amount lawsuit. So the industry average for pre-lawsuit debts, in the industry they call them pre-lit debt settlements, is 45%. So if you have a $100 debt, it will settle for $45 on average. The range is very broad, but that's the average. In lawsuit debts, they settle on average in the industry for 85%. So if you're being sued for $100, they on average settle for $85. With our platform, we only settle lawsuit debts right now. We're planning on doing pre-litigation settlement soon. We have a lower than average settlement rate. It's at 71%. Right, so that's what you're looking for. Realistically, with debt lawsuit settlements, the range again is very broad. Like we see debt settlement on our platform below 40%. Okay, so that definitely happens, but the average is 71%. So yes, in short, you can definitely reach out to them. All right, gallery, when can we start asking questions? Looks like right now. Okay, and I got to your question there. Let's see, who's up next? Dana, I have court next week. Attorney is not sure if they are junk buyer for Barclay in Alaska. If IRS sent 1099-C for charge off, can they still collect? Okay. So you have a court next week. Attorney is not sure if they are junk buyer. Okay, I'm not super sure I understand here. You're asking if somebody can collect. Generally, the answer is yes. Like, there's a very high likelihood that someone can collect. If someone tells you that they are trying to collect on your debt, you should definitely take them seriously, because it's really not a question of can someone collect on your debt. It's about whether or not you legally have a defense against someone collecting on the debt. All right, so people can certainly try to collect. Anybody can file a lawsuit against you for any reason without merit at any point in time. Right? If your brother decides that you owe him $1,000, he can file a lawsuit against you for $1,000. If you don't respond to that lawsuit, even if you don't owe him $1,000, you will lose that lawsuit automatically. And then once you lose that lawsuit, you will now legally owe that person $1,000. Okay, so nobody cares whether or not you actually owe the guy the money. Right? The judge doesn't. He's not going to bring that up for you. The only person that's representing you is you in this case. So in this case in Alaska, it doesn't really matter if they have legal right to collect. What matters is, are you going to question their legal right to collect in court? The only way to do that is to show up. So whether or not they have a legal right to collect, doesn't matter. You should show up in court in Alaska and defend yourself. Right? Because if you don't, even if they do not have any legal right, they will win that lawsuit if they show up in court and you do not. All right, so that's the general idea there. So definitely want to show up. All right, we got some other questions here. We got Patty. What is a typical first offer of settlement? Do you settle low and bargain up? Our learning on this topic has actually progressed quite a bit over time as we've seen more debt settlements happen successfully. We would have guessed, and I think people normally would guess that, yeah, starting low is a good move, and then you just kind of bargain up. What we found was that debt collectors are professional. They do this all the time. If somebody starts too low, they're going to think that that person is just wasting their time, and they aren't going to take the settlement offer seriously. They might not even respond. One of the few indicators we've really seen that can determine whether or not a debt is going to settle successfully is if the first offer is within 20% of the final settlement range. So that means it's much more likely to settle if both parties are within 20% of like what it ends up settling at. So with that in mind, most debts settle on 71%. So it might be advisable, if you want to get a settlement, to start off within at least 21%, at least 20% of 71%. So not lower than 51%. If your debt is, if you have some rationale to say that your debt should definitely settle for less, you might want to try that out. Otherwise, that's probably your range. All right, we got a question from Safi. Do I still have the option of getting a lawyer for my case even after I file the answer? I just want to get the answer over with for right now. but want help from an actual lawyer after. Yeah, you're not totally alone in that sentiment. So you can definitely get a lawyer after using us to file an answer. Certain people do that. A pretty cost-efficient way to file an answer. We have attorneys that we can refer you to in a few states like California, Florida. What most people end up doing, if you want to settle, we have a service called Solo Settle Assist. So you fill out an offer to settle, and then you click a link on the site, and then we will connect you with a law firm that can fully represent you in the case and take on your case from there, basically referring you to them, and they can settle across all 50 states. So that is a good route to go. They're the best lawyers in the business for this kind of thing if you want to settle. If you don't want to settle, maybe one of our other partnering lawyers might work for you. Got a question from Juan. Just responded to plaintiff's motion for summary judgment today. Can I still request for arbitration at this point, or is it too late? So you just responded to the plaintiff's motion for summary judgment. Can I still request arbitration? Yeah, you can still request arbitration. Yep, you can usually request arbitration up until the time that a judgment has been filed against you. All right, so you should be good. Alrighty. Ulysses, how should I wait for debt collection to answer my question summons? And I think Hannah answered that question. All right, skipping down to Bill. Had a debt lawsuit today in Kansas, was never served with a subpoena. I didn't show, only knew my son looked for his divorce case. Okay, so it sounds like you missed a court hearing for the debt lawsuit. So sorry to hear it. It probably means that you lost the debt lawsuit if there was a hearing today and you didn't show up. You probably lost automatically. As we mentioned earlier, you can email us and we can send you a motion to set aside judgment. You can file that alongside with your answer document. Has a good track record of getting the judgment overturned, especially if you weren't able to show up because you didn't know about the case, which sounds like the case here. So you can try to go ahead and go along that path. Got a question from Mark. I sent a dispute letter from you all to a debt collector. They sent me a letter back, and I didn't know what to do. Now it's showing up on my credit report. What do I do, or how do I get it removed? Okay, by a dispute letter, I think you mean a debt validation letter. If you disagree with the debt and you are not familiar with it, you believe that you don't owe the debt, then the debt validation letter requests that they remove it from your credit report, or at least they show it as disputed on your credit report, unless they provide validation of the debt. So if they didn't, that might be a Fair Debt Collection Practices Act violation, or an FCRA violation, something like that. Fair Credit Reporting Act, FCRA, yeah, violation. And if you want to get them removed off the credit report, you probably want to send them an FCRA letter, FCRA dispute letter, which you take, then you send that in, saying that you dispute this debt. We don't have an FCRA letter, but you can find them online. I think you might be able to find one on our blog. You might be able to find a template on our blog. Answers through SoloSuit are on the way to the court. Can you start negotiations now? Yes. So what most people do is you just file an answer on our software, on our site, and then immediately after you pay for that, you can then go over and make an offer to settle. And that's a good route to go. That's what I would do. Got a question from Anne. How much should I try to settle the debt for? I have 2 different lawsuits and potentially 1 more from the same law firm, but different companies. Should I try to settle all at once or each one separately? So our program is set up to work around specific lawsuits. So for us, you'll need to respond to each one individually. So you'll do 3 document responses, pay for each one. And then you will enter 3 settlement offers for each one offer for each case number. That's the way to go. All right, folks, we are 30 minutes after the hour. It's been great hanging out with you. I'd love to hear more from you. You've entered your questions into the chat. If you could just tell us what state you're in, just type the 2-letter abbreviation, or just tell us the name of the state that you're in. We'd love to hear from you. And then also, if you want to say, thank you to Hannah for helping out and answering our questions on the chat, that would be great. So thanks so much for coming on today. It's been a fun webinar. Always remember that we are in your corner at SoloSuit. So thanks a lot.